When you think about a hazardous materials response team, there's a very specific operational logic at play. A responder walks into a warehouse, they see an unmarked, leaking steel barrel, and they immediately set up a containment perimeter.
Right. They quarantine the area.
Exactly. They don't need to be a PhD biochemist. They don't need to, litigate the molecular structure of the chemical or determine who manufactured it or who holds the patent. They just recognize the hazard, they apply a rigid set of safety protocols, and they keep people away from it.
Okay, but I mean, the warehouse isn't full of clearly leaking barrels. It's full of complex interconnected systems. And what if the very act of determining which barrel is dangerous and exactly how wide that containment perimeter needs to be inherently requires you to analyze the molecular structure? Like, you can't contain a chemical fire without implicitly making a scientific judgment about what the chemical actually is.
Well, welcome to The Debate. In our world, that warehouse isn't full of chemicals. It's a client's digital footprint. And today we're asking a question that frankly haunts the living professional record framework, which is, can an advisor tell a client what is safe to share without accidentally practicing law?
Yeah, it's a huge question.
It really is. We're looking specifically at Module 06 of the LPR Academy curriculum today, which deals with privacy, consent, and governance. And the explicit tension here is whether an LPR advisor can effectively govern sensitive evidence without functionally crossing that line into legal advice.
Right, and the material itself places an enormous burden on this boundary. I mean, the curriculum insists that advisors must govern highly sensitive information while explicitly warning them not to present themselves as legal counsel unless they are, separately qualified. It's a tightrope walk.
It is a tightrope, sure, but I'll be arguing that it's a tightrope with a very robust safety net. The LPR framework provides a remarkably clear operational boundary. So, by utilizing strict tools and prescribed linguistic discipline, the advisor enforces what the text calls privacy-aware professional record governance.
Okay.
They operate on the foundational doctrine that proof is not permission, securing a client's professional truth without ever actually making legal determinations.
And I'm going to argue that this boundary is conceptually fragile. Honestly, it's an illusion of safety. The curriculum attempts to build a wall through prescribed language and operational tiers. Absolutely.
Because it works.
Does it? The functional reality of classifying and governing highly sensitive, employer-owned, or third-party evidence that inevitably requires judgments that are deeply, deeply, and inherently legally adjacent.
Well, let's jump right into the mechanism of how this boundary is supposed to work, because the curriculum is very explicit about it. It leans heavily on linguistic discipline. I mean, the text actually prescribes exactly what an advisor can and cannot say.
Right. Clip 8 in the material.
Exactly. Clip 8. It's a perfect example. An advisor is instructed never to say, "This is legally allowed," or "You definitely have the right to share this."
Yeah.
Instead, they have to say something like, "This appears sensitive. We should not use or upload it without confirming that it is safe and permitted." Or they might say, "This may require permission or professional review."
Right. It's a complete sanitization of the vocabulary.
I wouldn't call it sanitization, though. I'd call it a cognitive reframing. By mandating this phrasing, the advisor is structurally insulated from the practice of law. I mean, they aren't interpreting rights. They are managing risk through exclusion and default privacy. They're acting as a gatekeeper of safety based on a universal professional standard, not acting as a judge of legal rights.
Okay, I hear you. But let's pause and look at the functional reality of that reframing. Changing the vocabulary to avoid phrases like legally allowed is a smart procedural safeguard, sure, is brilliant liability protection for the advisor. But does changing the words actually change the nature of the action?
I think it does, yeah.
But an advisor is tasked with looking at a client's professional artifact and identifying sensitive material, things the curriculum explicitly calls out, like proprietary business strategy or personnel information.
Right.
When you decide that a document falls into one of those categories and you tell the client, "This appears sensitive, we shouldn't use it," you are making a profound risk assessment about liability and property. You just aren't using the word legal out loud.
But again, think of the advisor as a building inspector checking for fire hazards rather than a zoning lawyer.
Okay, walk me through that.
So a zoning lawyer has to litigate where the property lines are drawn and interpret complex municipal code, right? A building inspector just looks at a stack of oily rags next to a furnace and flags it as unsafe.
Sure.
The inspector doesn't need to practice law to recognize a hazard. Under the LPR doctrine, the full record is private by default. So when an advisor looks at an internal onboarding checklist, they apply the doctrine that evidence is not exposure. They use the privacy and exclusion log to track restricted uses. They're just spotting the oily rags.
That's a great analogy, I'll give you that. But let's push on it a bit. If a building inspector flags a structure as unsafe, they're doing so based on a codified, legally binding fire code.
Well, they are applying the law to a physical reality, even if they aren't arguing it in court. Let's look at your onboarding checklist example. If an advisor labels that checklist as summary only because, as the text notes, it's an employer-owned internal document,
Right.
they are actively enforcing a property right. The label they slap on it might say governance, but the entire reasoning is rooted in a legal concept, which is ownership. If you restrict a document because it contains a trade secret, you have implicitly made a legal judgment about what constitutes a trade secret in the first place.
I see the jump you're making, but the advisor isn't declaring that the checklist definitively meets the legal threshold of a trade secret under intellectual property law. That's a crucial distinction.
But they're treating it like one.
The advisor is simply observing that the document originates from an internal, employer-governed environment. Therefore, it triggers a governance protocol. It's a heuristic, not a ruling,
But a heuristic based on what?
based on operational boundaries. And we see this very clearly when we look at how the curriculum instructs advisors to handle redaction.
Oh, the mosaic effect stuff?
Exactly. If an advisor were playing lawyer, they might try to surgically redact a document, blacking out a name here, a dollar amount there, just to skirt liability. But the text explicitly warns against the phrase, just redact it.
Right.
It points out that redaction is not magic, because context, timelines, or a combination of details can still expose protected information through the mosaic effect. By refusing to play the redaction game, the LPR methodology sidesteps that entire legal swamp.
Wait, walk me through that.
You're saying that by realizing redaction doesn't work, they somehow avoid legal analysis?
Yes.
I'd argue the exact opposite. The text tells us redaction isn't enough, so it suggests using safe summaries instead. It provides a specific example, taking a confidential healthcare implementation and distilling it into the phrase, supported documentation and coordination for a regulated implementation environment.
A great summary, by the way.
Sure, but if I'm an advisor and I have to determine whether that specific summary has successfully scrubbed all identifying characteristics and legal liabilities, I am performing an incredibly sophisticated risk assessment.
You're performing a professional risk assessment. But the risk is legal. I mean, how do you know that the phrase regulated implementation environment doesn't still point to a specific hospital if combined with a timeline on the client's LinkedIn profile?
Well, you ask the client.
But making that call requires a deep understanding of how data combinations create legal exposure. You are interpreting the legal weight of the document in order to govern it.
Hold on, you're missing the mechanism the advisor uses to arrive at that summary. The advisor is not performing a legal liability test against a potential lawsuit. They are applying the LPR principle of minimum necessary proof.
Okay.
They ask, what is the absolute smallest amount of evidence needed to support this client's claim safely? And if there is any doubt about that safe summary, the curriculum provides the ultimate operational safety valve, which is the metadata-only label.
Okay, let's dig into that. How does metadata only actually solve the problem you're describing without requiring legal judgment?
Think of a metadata-only entry like handing an auditor a catalog of the library, rather than giving them the keys to the library itself.
Okay, I'm following.
The entry retains the existence of the artifact, the general type of item, say Q3 strategic report, the approximate date, and the client's role. But you do not retain or render the unsafe file itself.
Right, you just point to it.
Exactly. It proves the work exists without ever exposing the pages. If I see a document has patient names on it, I don't need to interpret HIPAA law to know it shouldn't go in a public portfolio. I just catalog its existence and lock it away.
I love the catalog metaphor. It really clarifies the action. But applying that metadata-only label still requires you to evaluate the file to know it's unsafe in the first place. I mean, you can't put something in the catalog unless you've assessed that the actual book is too dangerous to lend out.
Yes, but evaluating it for sensitivity is not evaluating it for legality. The LPR boundary is actually broader and stricter than the legal boundary.
How so?
A claim can be perfectly legal to share and still be inappropriate or unsafe to render publicly. And this logic is perfectly encapsulated in how the framework handles AI. The curriculum states unequivocally, do not upload protected material into AI.
Yeah, they are very firm on that.
Right. The advisor doesn't analyze whether an AI platform's terms of service violates a specific employer's NDA. They don't do a legal review of OpenAI's data scraping policies. They simply apply the governance rule, do not upload. They sidestep the legal analysis entirely by defaulting to exclusion.
I'll concede that defaulting to exclusion is a massively protective measure. It's smart. But excluding it from AI doesn't solve the underlying problem, which is the philosophical core of Module 6. Who actually owns that data in the first place?
Well, the worker owns the record. The curriculum is absolute on this. The LPR must not become a surveillance file or an employer dossier. The private source layer belongs to the individual.
Exactly. It says the worker owns the record. But at the exact same time, the text acknowledges a functional reality, which is that employers may own certain documents, systems, or data.
Yes.
So you have a client whose entire professional memory is wrapped up in employer-owned artifacts. Let's make this concrete. A client comes to you. They want to prove they increased revenue by 14% in Q3. And their proof is a highly proprietary internal strategic report.
Okay.
The advisor's job is to help them extract their worker-owned source layer from that employer-owned material. How can an advisor possibly navigate the extraction of professional truth from an employer's proprietary document without interpreting the legal realities of the client's employment contract?
By utilizing specific operational tags that diffuse the conflict entirely. For instance, in that scenario, the advisor can rely on the interview memory label.
Pause there. How does the interview memory label actually work in practice?
It essentially acts as a structural flag. It says, I am recalling this 14% metric from my own professional memory of the work I performed. I am not claiming to possess, nor am I rendering the original proprietary document.
Interesting.
It immediately diffuses the intellectual property issue because you aren't distributing the document. You are documenting the worker's lived experience. The advisor tells the client, the audience doesn't need the full report. We will log this as an interview memory. That is an act of professional boundary setting. It is entirely separate from giving legal counsel about what constitutes a breach of contract.
But the line between professional boundary setting and advising on a breach of contract is razor thin. If the client asks, can I show this slide deck to a recruiter? And the advisor says, no, let's use the interview memory label instead. The client receives that as, if I show the slide deck, I will get sued. They are coming to the advisor for risk management. The advisor is managing legal risk under the guise of professional governance.
But you're describing a scenario where the advisor is essentially guessing at the legal risk. The framework explicitly trains them not to do that. There is an explicit non-legal scope warning built directly into the process.
I know the one.
Let me quote it for the audience. When legal, contractual, regulatory, classification, employer policy, or data rights questions arise, pause, protect the client, avoid use, and seek appropriate review. Doesn't this directive to pause and avoid use solve the exact tension you're raising?
I don't think it does, no.
The advisor doesn't interpret the employment contract. The moment it gets legally complex, they halt the process.
I completely agree that pause and avoid use is an excellent protocol. It really is. But my point is about when that protocol is triggered.
What do you mean?
Recognizing that a data rights question has arisen requires you to know what a data rights question looks like in the wild. If a client brings in a document from a previous employer, let's say it has no markings, no confidential stamp, but it details a highly specific vendor workflow, recognizing that as a potential intellectual property issue requires a legally attuned mind.
Does it, though?
Yes! The material tells advisors they must identify high-risk categories, like performance discipline records, security information, or investigation materials. You cannot identify these effectively without a working mental model of the legal frameworks that make them sensitive. I am not saying the advisor is drafting legal briefs. I am saying the intellectual radar required to know when to pause rests on a foundation of legal assessment.
I see the logic there, I really do, but I have to push back on the idea that identifying a sensitive category requires a legal mental model. Let's look at something incredibly common in the LPR, which is witness testimony.
Okay.
The text notes that witnesses are crucial for making claims believable, but they are not surveillance notes. Before using a manager's name or quote, the advisor has to run through a witness consent checklist. They literally just ask the client, did Maria give permission for you to use her quote, and for what specific use?
Right, establishing consent.
Exactly. But asking that question doesn't require the advisor to understand the tort of public disclosure of private facts. It doesn't require them to know case law and defamation. It just requires knowing the operational rule. In the LPR framework, names require consent. The advisor is enforcing professional ethics, which operate upstream of the law.
Upstream is the perfect word for it. Because when you are upstream, whatever you dump in the water eventually flows down into the legal system. Let's go back to the prescribed phrasing from clip 8 that we started with.
Okay, sure.
The advisor is trained to say, this appears sensitive. We should not use or upload it without confirming it is safe. From the advisor's perspective, they are staying in their operational lane. But from the client's perspective, the functional outcome is identical to legal advice.
I disagree.
The client wants to know what they can safely put on LinkedIn. The advisor says, we shouldn't use this. The client takes that as, my former employer will send me a cease and desist if I do. The language is meticulously scrubbed of legal terminology, but the service being rendered is a legal risk management service.
I'd argue that is exactly how comprehensive professional governance should work. Yes, the client is receiving risk management advice, but it's a much wider umbrella. It's reputational risk, ethical risk, and professional risk, not just legal risk.
But legal is in there.
Sure, but like the text says, a claim can be true and still unsafe to render. If a client wants to share an incredibly aggressive email they wrote that proves they solved a technical crisis, it might be 100% legally fine to share, but the advisor will say this is unsafe externally because it makes you look impossible to work with.
Yeah, that's fair.
The LPR boundary keeps you so far back from the cliff that you never even see the edge. By staying within the operational boundary, the legal boundary becomes a moot point.
It's a very clean theoretical model, I'll give you that. But the messy reality of human careers often forces you to walk right up to that cliff edge. Think about the privacy and exclusion log.
Right, tracking the artifacts.
The advisor has to track the item, the privacy label, the exact reason for restriction, and the forbidden use. If the reason for restriction is proprietary business strategy and the forbidden use is do not upload to AI, the advisor has essentially conducted a mini discovery process on the client's evidence. I respect the framework's intent, and the tools are incredibly rigorous. But evaluating highly sensitive employer-owned evidence to determine its safety tier inherently borders on legal risk management. The curriculum builds a beautiful linguistic wall, but the daily practice of an advisor involves leaning right over it to get the job done.
Well, we've covered a lot of ground today, so let's summarize where we've landed. My view remains that the LPR framework succeeds precisely because it doesn't pretend the law doesn't exist. Rather, it builds an operational fortress that keeps the advisor safely away from it.
A fortress of vocabulary.
Well, by strictly adhering to LPR safe use disciplines, defaulting the full record to private, utilizing tools like the metadata catalog and the interview memory tags, enforcing strict AI upload prohibitions, and above all, pausing when rights are unclear, the advisor successfully maintains a rigid boundary. The prescribed language from Clip 8 isn't just a liability shield, it's a cognitive tool that keeps the advisor focused purely on professional truth. The boundary holds because the mechanisms enforce it.
And my perspective is that while the framework provides arguably industry-leading protective protocols, the nature of the work defies a perfect operational boundary. The act of sifting through raw, messy professional evidence, separating a worker's memory from an employer's property, and translating sensitive artifacts into safe summaries requires judgments that are profoundly legally adjacent.
Right.
Changing the vocabulary to avoid phrases like legally allowed is a vital procedural safeguard, but it doesn't change the fact that governing data rights, privacy, and consent requires a legally attuned radar.
We do certainly find some strong areas of convergence, though. We completely agree on the fundamental brilliance of the doctrine that proof is not permission.
Oh, absolutely.
The distinction between possessing an artifact in your private source layer and having the right to render it publicly is just vital. And we absolutely agree on the hazards of AI.
Yes. The AI upload risk is perhaps the most immediate hazard any professional faces today. The curriculum's absolute prohibition on uploading protected material because a single careless prompt can expose an employer's intellectual property is both necessary and correct.
Definitely.
It has been incredibly valuable to look at this material through your operational lens. The tension between preserving a comprehensive professional truth and managing the reality of exposure is one of the richest areas for exploration within this entire framework. There is going to be so much more to explore in how advisors handle these edge cases in the wild.
Indeed. We will leave it to the listener to determine if the LPR framework provides a sturdy operational wall or if the boundary remains a blurry line in practice. But as you think about it, remember that warehouse from the beginning of our discussion. Whether you are building an elaborate chemical containment strategy or simply stepping away from a leaking barrel, the most important thing is that you don't track the hazard out the door with you. Thank you for joining us on The Debate.